Now, children, as we all know, are the future of the society. Therefore, it is imperative that in every civilized society, children are taken on priority in any policy formulation. India has over a period of time evolved various child-friendly laws. But along with that, we also need a child-friendly and child-sensitive society. Despite the constitutional vision of a healthy and happy child protected against abuse and exploitation and a national policy for children, the majority of children in India continue to live without a cared, protected and meaningful childhood. The juvenile justice system, as conceived by the legislation, aims at providing care, protection, treatment, development and rehabilitation of delinquent and neglected juvenile. If we can control juvenile delinquency and restore them in a mainstream, we shall be doing a great justice to our future. We have to realize that no child commits a crime with the intention of a criminal mind. He or she is more often than not compelled by circumstances. Besides that, India also has a very disturbing social fact of child labor, child soldiers, child sex trafficking. Now, the substantive as well as procedural criminal law of India provides a number of provisions dealing with safeguards of child rights against violations. Section 82 in the Indian Penal Code states that nothing is an offence which is done by a child under 7 years of age. Similarly, Section 83 in the Indian Penal Code states that nothing is an offence which is done by a child above 7 years of age and under 12 years, who has not attained a sufficient maturity of understanding to judge of the nature and consequences of his conduct on that occasion. Section 293 deals with selling, distributing obscene objects to any person under the age of 20. It is an offence amounting to 7 years in jail. Section 315 till 318 deals with the act done with the intent to prevent child being born alive or to cause it to die after birth, as well as concealment of birth by secret disposal of the body. It is also punishable to abandon the child under 12 years by parents or any person taking care of it. The punishment of such offences varies from 7 to 10 years in jail. The internationally accepted rights of children flowed from the United Nations Conventions on Rights of the Child, which is UNCRC, which is the first international legally binding document concerning child rights. After ratification of UNCRC, Parliament of India not only made amendments to the then existing laws, but also enacted new laws to protect and promote the rights of child as mandated by the said conventions. The following are the major criminal enactments made by Indian Parliament for protection of rights of child. Number 1 is Juvenile Justice, which is Care and Protection of Children Act 2000. Number 2 is the Protection of Children from Sexual Offences Act 2012. Now, the Juvenile Justice, Care and Protection of Children Act 2000 is the primary legal framework for protecting rights of children in India. The object of the Act is prevention, which is ensuring that children do not come in conflict with the law, diversion, that children are kept away from formal criminal justice system and into community-based restorative processes to prevent repeat delinquency. Then protection from human rights violation and the children from exploitation and abuse. The mission being to not to simply punish the violators, but to help the young violators of law to get back in the society on the right path. The JJ Act defines child or juvenile as a person who has not reached the age of 18 years. The Act classified children into two categories: juvenile in conflict with law and child in need of care and protection. Juvenile in conflict with law. What does it mean? It means a juvenile who is alleged to have committed an offence and has not completed 18 years of age as on the date of commission of such offence. That's the definition. Now, what does child in need of care and protection mean? This category of children include any child who is orphan, homeless, beggar, street children, working child, or a child residing with a person who threatened to kill or injure the child, or a mentally or physically challenged child, or ill children, or children suffering from terminal or incurable diseases, or children of unfit or incapacitated parent, or abandoned or surrendered child, or missing and runaway child, or a child who is being or is likely to be grossly abused, tortured, or exploited for the purpose of sexual abuse or illegal acts, or vulnerable child and is likely to be inducted into drug abuse or trafficking, or a child who is being or is likely to be abused, or a child who is victim of any armed conflict, civil commotion, or natural calamity. The Act provides for establishment of two competent authorities for dealing with the cases of the above two categories of children, that is the Juvenile Justice Board and Child Welfare Committee. Now, the state government is obligated to constitute one or more juvenile justice boards and child welfare committee for every district to deal with the cases of juvenile in conflict with law and child in need of care and protection, CNCP. What is the meaning of Juvenile Justice Board? Now, this board consists of a judicial magistrate of the first class having training in child psychology or child welfare and two social workers who have been actively involved in health education or welfare activities pertaining to children for at least 7 years, of whom at least one shall be a woman, forming a bench, and every such bench shall have the powers of a judicial magistrate of the first class. Every criminal complaint where allegation is made against a person under 18 years of age shall be tried by Juvenile Justice Boards, the JJBs. A claim of juvenility may be raised before any court at any stage. Even after final disposal of the case, a claim of juvenility shall be decided by seeking evidence by obtaining the matriculation or equivalent certificate, of course if it's available, and in the absence whereof the date of birth certificate from the school other than a play school, that is first attended school, and in the absence whereof the birth certificate given by a corporation or a municipal authority or a panchayat, and only in the absence of either the medical opinion will be sought from a duly constituted medical board, which will declare the age of the child. In case exact assessment of the age cannot be done, the court or the board may give benefit to the child or juvenile by considering his/her age on lower side within the margin of 1 year. Apprehension of juvenile in conflict with law. A juvenile has a right not to be dealt with by other police officer other than the juvenile or child welfare officer of a special juvenile police unit, which is called SJPU, who shall be dressed in plain clothes. You cannot dress in police uniform. In no case a juvenile in conflict with law shall be placed in a police lockup or lodged in a jail, and he should be produced before JJP within 24 hours of his apprehension. Bail should be granted except where there appears reasonable grounds for believing that such release will be detrimental to him or that his release would defeat the end of justice. In such case, the child shall be kept only in an observation home or a place of safety for such period during the pendency of the inquiry. The inquiry shall be completed within a period of 4 months from the date of the commencement. That is very important. Now, order that may be passed regarding juvenile. Where a board is satisfied that a juvenile has committed an offence, the board may, firstly, allow the juvenile to go home after advice or admonition and counselling. Secondly, direct the juvenile to participate in group counselling. Thirdly, order the juvenile to perform community service. Order the parent of the juvenile or the juvenile himself to pay a fine if he is over 14 years of age and earns money. Direct the juvenile to be released on probation of good conduct and placed under the care of parent, guardian or any other fit person. And make an order to a special home for a period of 3 years. No death penalty or life imprisonment can be passed against a juvenile. The Act prohibits joint trial of a juvenile with adult in any criminal proceedings. It has to be separately dealt with. Now let me little bit talk about Child Welfare Committee. The Child Welfare Committee, which is called CWC, shall consist of 5 members, of whom at least one shall be a woman and another an expert in matters concerning children. The committee shall have the final authority to dispose of cases for the care, protection, treatment, development and rehabilitation of the children, as well as to provide for their basic needs and protection of human rights. Any child in need of care and protection may be produced before the committee by any police officer or special juvenile police unit or a designated police officer, any public servant, a child line, any social worker or a public spirited citizen, or by the child himself, which shall conduct an inquiry and pass necessary order either to keep the child in a children's home or restore the child to his or her parents or guardians or a fit person. Child care institutions. Now, Child Care Institutions Act provides for the following homes for taking care of children who are either child in need of care and protection, which are called CNCP, or juvenile in conflict with law, which is called JCL. We have children's home for the reception of child in need of care and protection during the pendency of any inquiry, and subsequently for their care, treatment, education, training, development and rehabilitation. That's very important. Then we have something called shelter home, that is for reception of children in need of urgent support. There are observation homes for temporary reception of any juvenile in conflict with law during the pendency of any inquiry. There are also special homes for reception and rehabilitation of juvenile in conflict with law after completion of inquiry for re-socialization of a juvenile. The following are the special offence under the JJ Act. There is section 21 which prohibits report in any magazine or news or visual media which may disclose the name, address or school or any other particular calculated to lead to the identification of a juvenile or child regarding which an inquiry is being conducted by either juvenile justice boards or CWC, except where such disclosure is in the interest of the juvenile or the child. Contravention of the said provision attracts punishment of fine which may extend to rupees 25,000. Then we have section 23 which provides for punishment with imprisonment for a term which may extend to 6 months or fine or with both for committing assault, abandons, expose or willfully neglect the child or making other person to do so in a manner likely to cause such child unnecessarily mental or physical suffering. There is section 24 which penalizes a person who employs or uses any child for begging with imprisonment for a term which may extend to 3 years and shall also be liable to fine. There is section 25 which penalizes a person who gives or causes to be given intoxicating liquor or drugs to a child except upon the order of duly qualified medical practitioner with imprisonment for a term which may extend to 3 years and shall also be liable to fine. There is section 26 which penalizes a person who procures child for the purpose of any hazardous employment, keeps him in bondage and withholds his earnings or uses such earning for his own purpose with imprisonment for a term which may extend to 3 years and shall always be liable to fine. Section 27 provides that the offences punishable under section 23, 24, 25 and 26 are special offences and are cognizable. Section 28 provides that where special offences is an offence under another act, the offender found guilty of commission of such offence shall be liable to punishment only under such acts as provides for the punishment which is greater in degree. Now let me tell you something about Special Juvenile Police Unit. The main role of the police is more of a compassionate elder who aids them and counsel them. At the police level, a separate system of juvenile welfare officers at the police station level, special juvenile police units at the district level and state nodal unit at the state level are required to be set up to upgrade the treatment meted out to the children at the hands of police to a more humane and sensitive approach. Police personnel are refrained from wearing uniform while dealing with the child and required to use terminology such as apprehended instead of arrest. This is just an example, there are many others. Let me talk about adoption. The JJ Act also provides provisions for adoption for orphan, abandonment or surrendered through such mechanisms as may be prescribed. State government is obligated to recognize one or more of its institutions or voluntary organizations in each district as specialized adoption agencies for placement of orphans, abandoned or surrendered children, which shall facilitate adoption after obtaining fee for adoption certificate of concerned Child Welfare Committee. Protection of Children from Sexual Offences Act 2012. The Act provides for stringent punishment which have been graded as per the gravity of the offence. It ranges from simple to rigorous imprisonment of varying periods, which may extend to the natural life of the accused. The Act is gender neutral and has a clear definition for all types of sexual abuses like sexual harassment, penetrative or non-penetrative sexual abuse, pornography. Sexual offences are currently covered under different sections of IPC. However, the IPC does not provide for all types of sexual offences against children, and more importantly, does not distinguish between adult and child victims. An offence is treated as aggravated when committed by a person in a position of trust or authority of child, such as members of security forces, police officer, public servant, etc. And in such cases, punishments are more stringent. We also have special court. The Special Court Act provides for the establishment of special courts for trial of offences under the Act, which shall complete the trial within a period of 1 year as far as possible. Now, what are the procedures? The Act incorporates child-friendly procedure for reporting, recording of evidence, investigation and trial of offences. These include recording the statement of the child at the residence of the child or at the place of his own choice, preferably by a woman police officer not below the rank of sub-inspector. Evidence has to be recorded within 30 days. No child is to be detained in the police station in the night for any reason. Police officer cannot be in uniform while recording the statement of the child. Only the exact spoken words of the child can be recorded, which is also called verbatim. Assistance of an interpreter or translator or an expert or special educator as per the need of the child must be provided. Medical examination of the child can be conducted in the presence of the parent of the child or any other person in whom the child has trust or confidence. In case the victim is a girl child, the medical examination shall be conducted by a woman doctor. The court need to grant frequent breaks for the child during trial. A child cannot be called repeatedly to testify. No aggressive questions or character assassination of the child in camera trial of cases. For the more heinous offences of penetrative sexual assault, aggravated penetrative sexual assault and aggravated sexual assault, the burden of proof is shifted on the accused. This provision has been made keeping in view the greater vulnerability and innocence of children. Special Juvenile Police Unit (SJPU) is to provide for the relief and rehabilitation of the child as soon as the complaint is made to the Special Juvenile Police Unit or local police. It will make immediate arrangements to give the child care and protection, such as admitting the child into shelter home or to the nearest hospital within 24 hours of the report. The SJPU or the local police are also required to report the matter to the Child Welfare Committee within 24 hours of recording the complaint for long-term rehabilitation of the child. The Act also made it clear that under situations in which the child who is being taken for the medical facility or an emergency factor, no documentation or magistral requisition would be demanded before the treatment. The rules laid down in the Act also had define the criteria of awarding the compensations by the special court that includes loss of educational and employment opportunities along with disability, disease or pregnancy suffered by the subject as a consequence of the abuse. This compensation would be awarded at the interim stage as well as after the trial ends. Now let me just conclude by saying this. Thus recently there are some steps being taken to improve the condition of juvenile homes. According to the latest Delhi High Court order, inmates at the juvenile observation homes will now be segregated according to age and behavioral pattern. This is a real breakthrough. They will also be monitored by personnel during meetings with their families. The government has also asked NGO running non-formal education classes in juvenile homes to provide classes in dance, aerobics, sports and meditation to inmates as a means to curb incidents of violence in their homes. But the situation needs very urgent remedies as the situation of these homes is very pathetic. Healthy food, recreational activities, schooling, child counselor services, work trainings to make them employable and a soothing and clean environment in these homes will go a long way to push these children away from the crimes and help them become better citizens. Children are soft, godly creatures. It is a society which makes them do unlawful things. Therefore, it is the duty of the society to enable them to revert to their beautiful and innocent childhood. Thank you.